Chair, Chair, we are ready.
Así es. Y en cambio este sí tiene que ver con la integridad del proceso electoral.
Continuamos, ¿no? Ajá, ponga orden, presidente.
Hi, everybody. Again, we are ready to start the last panel of this conference. Hi, thank you. Excuse me. Don't let me get the impression that it's easy to deal with political parties in Mexico than with scholars in Boston, please. Well, we're ready to start the last panel of this conference. I'm very glad to present Mari Carmen Alaniz and, Carmen Alaniz and Daniela Urosa. Yesterday, Carmen was already presented. I just remember that she's the director of the Center for Mexican Studies in the National University, Autonomous University of Mexico, the UNAM, here in Boston. And she was a member of the Electoral Court in Mexico and the first woman president of that court on one hand. And on the other hand, we have Daniela Urosa. She has not been presented yet here in the conference, so I'll be I take a little more time to get some highlights of her curriculum vitae. She has a PhD in law for the Universidad Complutense in Madrid. She's also professor and director of the Master of Constitutional Law and Master in Administrative Law at the Universidad Católica Andrés Bello in Venezuela. She's the vice president of the Venezuelan Association of Administrative Law, and she has written some books and papers about electoral law, administrative law, electoral justice, which is the issue of our panel. And right now, as you will know, she's currently visiting scholar in Boston College Law School. So, if you don't mind, you have 20 minutes, if you agree. And in first instance, Mari Carmen Alaniz.
Thank you. Thank you, Daniela, for considering me in this panel. And sorry to all of you. Twice, it's a lot. It's an exaggeration. But I'll try to be very brief and just put on the table some issues that I think are of such importance for the electoral integrity models that we are creating and working on, because I think that we are still working on a universal model of electoral integrity. And I'm inviting you and myself to keep working on that, because it's not an index and it's not only a way of participating, observe, and discuss about elections. So we have to put everything together that we are working on and keep studying and reflecting about what electoral integrity is. And before starting, let me tell you that I'm part of the Electoral Integrity Initiative of the Kofi Annan Foundation. They don't have an index. They have an initiative, and they are still creating the model. And Mr. Annan was very aware of the necessity of working all the international agencies and international observation groups and the electoral authorities and practitioners on these issues. And as you probably know, he created the Global Commission on Elections and Security in 2013 and 14, and before he unfortunately passed away a few months ago, he called for the second Global Commission on Elections, Democracy, and New Technologies. It will be formally presented next year or at the end of this year. And you can go through the webpage of the Kofi Annan Foundation. So I'm mentioning this because he, before passing away, included new technologies, but he insisted a lot of access to justice as a transversal part of the electoral integrity projects. Whichever it is, access to justice as the same level as rule of law is of such importance to consider. They are, Emilio is telling me, look at this side, to consider as a transversal line in this model. So what I want to start with is that it was very common to think about electoral justice just about a model of challenging elections, electoral results, or something that is not correct in the electoral process cycle. But we didn't model, we don't have an access to justice model based on principles and the protection of rights permanently. It's not only during the elections, it's not only during the turnout, during the results of the election. So it's a permanent system of protecting human rights. And we have to model that in the electoral integrity process. So we have to create the mechanisms and structures to guarantee equal protection of the law for everyone to process claims within a reasonable time and to do so with independence and impartiality. So we always have put less attention to this, to the rule of law and the protection of human rights in an electoral process, which makes a huge difference instead of talking about challenging or contesting electoral results. So for me, these are essential preconditions of electoral integrity. Broad public access to justice at all levels, including remedies. This is essential to prevent violations of human rights. So we have to scope this access to justice or electoral access to justice or constitutional review of elections protecting human rights. The other element that for me is essential is timely redress. If we are as courts or as administrative authorities solving something related to the violation of human rights, political rights in an elections, we don't have lots of time to solve this, to rule about this. We have to act like this. And this is only understandable before electoral courts in Latin America. Nowhere all around the world they act as fast and as timely as the electoral courts in Latin America. We are solving cases in days, in hours, in order to protect human rights, the exercise of political rights, and to redress the person when its rights, his or her rights, were violated. So if you are challenging your opponent because he's threatening you, or because he's triggering an election, or she's triggering an election, or doing something against law that is affecting you, nothing happens if the court or the electoral administrative authority resolves that in 1.5 years. Well, you need to be solved that case in hours, because after that, there's no redress possibility. So we have to take this into account. We cannot go through or before ordinary justice if we are talking about the exercise of political rights which are human rights, as we saw yesterday. So we have to solve fast and redress, timely redress. So I mentioned that it's permanent, and also we have this model of access to justice have to be more inclusive and flexible. We have to enlarge the access to justice door. We cannot be as strict as in an ordinary legal process when we are dealing with these issues. So we are dealing with groups that traditionally are discriminated, so we have to enlarge the access to justice possibility. If we are dealing with indigenous people, persons, or indigenous communities, we have to accept collective actions and immediate protect or resolve protection measures. If we are dealing with disabled or people with disabilities, we also have to take measures to protect them and give them all the major possibilities to participate in a political process. If we are dealing with an active politician that has no permission to speak in Congress because of his party leader doesn't allow him, which is the instance to go before to challenge that action? So if we are talking about active politicians, we have to take measures like this. Probably you are thinking, is that a political right? What's the relation with elections, or why a political or an electoral court or administrative electoral authorities dealing with these issues? Because if we are not dealing with these issues, there is no instance at all to protect the exercise of those political rights. So what I'm trying to tell you is that it's much more broadly, or the way that we have to act if we are dealing with electoral justice. I love to mention this and to show this slide because electoral courts in Latin America also are dealing with right to information, right to free speech, right to free assembly, right to political participation, which is not common that these cases go before the electoral court. This is civil law, no? This is private, no? This is not private. Latin American courts are solving this related to the exercise of a political right, and these are human rights. But if we take these cases to ordinary justice, probably in 3 years, 5 years, we get a ruling from the ordinary court. So in Latin America, we are taking these cases to the electoral, judicial, and administrative authorities' competence. So that's why the impartiality and independence, I put here judges, but it's also administrative authorities, are equally preconditions of electoral integrity and access to justice. Because now we are dealing with the protection of human rights, and the rulings of the electoral courts and of the electoral administrative authorities in some countries are the last instance. They are not reviewed by the Supreme Court or constitutional courts. So the way that judges and the highest level authorities, electoral authorities, are appointed are of such importance. So these are also principles that have to be taken into account if we are modeling or talking about electoral integrity. So I choose just to mention, I'm not going very deep, as a case study, violence against women in politics. It was mentioned yesterday. So this is a topic, a theme, a problem, a violation of human rights that it's not legislated at all. Bolivia is the only country in the world which has ruled political violence against women in a national law. Mexico has ruled it in 29 states, so it means at local level, but not at national level. I don't will answer. What do you think, why? Well, because if it is absent in the legal framework, the legal conceptualization, the formal procedures, prevention, sanctions, and reparations, if it is not ruled, then authorities cannot act. So I remember when we went together before the Senate, we were like 20 women with women legislators to present a draft law, and Lorenzo will remember this. Senators, male senators, and representatives from the executive told us, that doesn't exist. Give us cases, we need facts. And then the next time we gave them files of the cases we already have, evidences and everything. And they told, you want to send all men to jail. So your initiative or your draft is very criminalized. So forget about crimes. If you present a law draft with administrative sanctions or administrative responsibilities, probably. Okay, so it was on purpose, and it is on purpose that they haven't approved a reform dealing with violence against women in politics. And you have here the legal principles. It's against law to punish someone for a crime not legally recognized. It is against law to sanction someone if there is not a specific sanction for that specific crime or offense. And it is against law if an authority sanctions someone without an expressed duty in law. So what we did in Mexico, and it is been taken as a good practice by regional organizations such as the OAS, the Inter-American Commission of Women, is to work with protocols. So the authorities, the competent authorities that deal with electoral processes, elections at national and local level, we work together and we approved a protocol to attend violence against women in politics. And it was approved by all the highest authorities, and we coordinated and we received all the cases that were presented before the administrative authority or the court or the attorney, and we were in contact and we attended those cases, and then we started to have specific rulings, jurisprudence, and precedents, administrative precedents at INE, and now we are evaluating and attending all cases without law, but through a conventional and constitutional review, interpretation of these of international precedents and criteria. Now the Electoral Court approved jurisprudence, which is compulsory for all authorities. So we didn't need the law, okay? But then you find the wall when you receive these cases, and that you are, that there's the responsibility of someone, but you cannot punish that someone because it is not in law. So you cannot sanction someone through analogy. Okay, this is like an homicide, but you can send that case to the criminal judge to judge it, but it will take lots of time. But as an electoral offense or an electoral crime, because we have a list of electoral crimes, the administrative authority and the court solve with a gender perspective and protect women against these cases. So in Costa Rica, in Colombia, in Bolivia, in Argentina, we can find precedents such like this to protect human rights of women as victims of violence in politics. So I choose this example of political violence against women because through justice, through electoral justice, we can advance. So electoral, and it happens also with indigenous communities and persons, with LGBTB communities. We are facing tremendous cases of supplantation of transgender candidates because we have quotas, and then their group says, no, he or she is not trans. The political party registers him or she to achieve the quota. So these kind of cases deals with the protection of human rights through the most guaranteed participation of the administrative and electoral courts. So we need to open our scope about electoral justice if we are talking about electoral integrity, and never think again that the challenge of an election it only deals with electoral results or the electoral management of an election. It deals with the protection of political rights, which are human rights. And let's keep working on this model because the door to accessing to justice is still very narrow. Thank you.
Thank you very much, Carmen. First to give the floor to Daniela, I would just like to remember that, for instance, in Mexico, but it's not the only country, the activity, the intervention of courts and administrative authorities were the first step to improve, in first instance, affirmative actions in matters related with the empowerment of women in politics, such as quotas, then parity, and right now violence. I mean, and it was the first step that after were taken, measures that were taken by the legislative branch to become laws. I mean, I think the role is very clear, and this is a very good example on how, I mean, the activity, the intervention of the tribunals, of the courts, is very important building law, as it always happens, but particularly in the defense of women's rights or political rights in general. Daniela, please.
Many thanks, Professor Cordova. It's a pleasure for me to share this panel with you and with Professor Alanis. And it's a challenge, of course, to be the last one of these 2 wonderful days after 16 great speakers, but well, I will do my best. I will address some ideas about a particular problem of electoral justice, that is the so-called electoral judicial authoritarianism. It's a topic, I think, an in-between of the last panel and this panel. So We have a lot of both, and both panels helping me a lot to be short with my ideas. As Professor Alanis explained it before, a core component of the electoral integrity is to build an effective and impartial institutions to settle electoral dispute without the authority to control the electoral acts and results. Those are precisely the main goals of the electoral justice. Electoral justice is a guarantee of electoral integrity, at least due to 4 reasons. First, because it's a guarantee of the political rights, right to vote, and the right to political participation mainly. Second, because it's a guarantee of the right of the access to justice and due process, as Carmen was explaining, in an individually or a collectively way, both. Third, it is a guarantee of the rule of law and constitutional democracy, of course. And fourth, it is a guarantee of transparency, competitiveness, and accountability of the elections, and in consequence, is a guarantee of the electoral integrity. Electoral justice is the final custodian of the electoral cycle. Any failure in the electoral integrity condition could be restored by the electoral justice. However, because it's a powerful institution, electoral justice can be also a threat when it fails to guarantee the electoral integrity conditions, or even worse, if it contributes to decimate those conditions. As I said before, I want to expose today what is probably the most dramatic case of the electoral justice failure, the electoral judicial authoritarianism, which happens when the electoral justice is misused as a political weapon in an active way, like a constitutional hardball in terms of Mark Tushnet, to overrule fair and transparent elections, or to avoid a control over unfair elections. In few words, I think it's the dark side of this great force that is the electoral justice, as was described by Carmen. But when does electoral judicial authoritarianism happen? It happens when an authoritarian government is supported by the electoral justice, which rules as an executive branch's arm to keep it in power. In other words, it happens when the electoral judges lost their independence and become a political actor in favor of an authoritarian regime. It is not simply some isolated judicial decisions with partiality for one or other party. This is important, are not isolated decisions. It is a reiterative and active judicial behavior controlling elections with an anti-democratic purpose. And why does electoral judicial authoritarianism happen? In the last panel, we were talking about that, and they explained very well this problem. In her book, Why Election Fails, Professor Pippa Norris explains how the state capacity and the behavior of public servants is key for electoral integrity, more than the formal legal structure or election authorities and electoral judges. And this is absolutely true, and is the cause of the electoral judicial authoritarianism. When there is not enough state capacity to keep and reinforce the check and balance system and keeps the judicial independence, any court, including the electoral court, could become a political tool of the executive branch. In that cases, the electoral justice will help to dismantle the electoral integrity conditions or keep the current flawed and rigged conditions of the electoral system. In that sense, it is important to determine what is the meaning of electoral justice in terms of electoral judicial authoritarianism. When we talk about electoral justice, we are referring to the judicial system of resolve electoral dispute that include all the judges and courts that decide about electoral matters, controlling electoral procedures and protecting electoral rights. So, in so many cases, could be only a specialized court, the electoral court, but in other cases, it's also criminal courts, constitutional courts, or even international courts ruling about electoral matters. This is the concept of electoral justice. In the recent Latin American elections, electoral judicial authoritarianism has been present, especially in Venezuelan case. Let's analyze briefly how the electoral judicial authoritarianism has appeared and increased in Venezuela in the last years and its main consequence. First, we can talk about the electoral justice in Venezuela, de jure, very briefly. The Venezuelan constitution regulates a complete system of electoral justice. According to the Venezuela electoral law, the electoral justice is, de jure, an effective system capable to control every electoral election before, during, or after the election. In that sense, Venezuelan electoral justice has the authority to declare null and void any electoral result, give orders to the electoral administrators and political parties, check irregularities in any step of the electoral cycle, and also take preventive measure in any time. Also, of course, as Carmen explained, allows to protect human rights, especially political rights, and it has even the authority to order new elections. Electoral justice in Venezuela is exercised by a specialized court, the Electoral Chamber or Electoral Court of the Supreme Tribunal, which is a one-instance court composed by 5 judges. But also, the electoral justice in Venezuela is exercised by the Constitutional Court, that is the highest instance of constitutional judicial review in any matter of constitutional law, included electoral rights. In consequence, both electoral court and the electoral court, and the constitutional court are pieces for the Venezuela electoral justice. Therefore, anyone who just read the Venezuelan constitution and the Venezuelan electoral law can conclude that we have a great electoral justice system, but nothing is further from the reality for sure. Let's see how is the electoral judicial authoritarianism in Venezuela, or de facto. De facto, the situation is really different. Neither the electoral court nor the constitutional court have been impartial tribunals. Since their creation in 1999, these courts have not issued a single decision against the government party. Since 2000, the independence of the judiciary was dismantled through several executive actions that particularly decimated the autonomy of the Supreme Court and all the chambers of the Supreme Court, including the Electoral Court and the Constitutional Court. At the same time, during these years, Venezuelans suffered a progressive dismissing of electoral guarantees, as was explained before by Professor Alarcón. Even though Venezuela was considered, as he explained, a competitive electoral authoritarianism, which means that despite the rigid electoral rules, elections could be a mechanism to canalize political participation and promote political changes. This situation changed dramatically since 2013. Between this year and 2018, the regime of Maduro increased the political control to the point that the low levels of competitiveness disappeared. The degeneration of Venezuelan electoral system to a non-competitive authoritarianism had several milestones, as we can see. No free elections, opposition candidates are all disabled, imprisoned, or exiled. Most of the opposition political parties have been outlawed, and the 85% of media is controlled by government. So the degeneration of the Venezuelan electoral system affects particularly the electoral justice. In that sense, the electoral justice not only decided to preserve the rigid electoral rules, but also it adopted several decisions that contribute to the dismantling of the electoral integrity conditions in favor of the president. It was a clear case of judicial authoritarianism. Instead of acting as the custodian of the electoral system, the electoral justice decided to act as one of the perpetrators of the electoral fraud that consolidate the authoritarian regime of Maduro that was explained before. Let's see briefly 5 cases of the electoral judicial authoritarianism in Venezuela. The first case is the presidential election in 2013. This election was clearly unfair elections just after the death of the president in office, Hugo Chavez. The vice president in this moment, Nicolás Maduro, was at the same time the government candidate and temporary president. The difference in votes, even though the bad conditions between both candidates, Maduro and Capriles, was less than 2%, and against these electoral results, 10 claims were filed before the electoral court. However, the Constitutional Court ruled inadmissible. The Constitutional Court advocated all the claims. Instead, the electoral court and declared inadmissible all of these claims. The court considered, without further legal analysis, unfounded the petition and, in consequence, inadmissible, even though most of them explained in hundreds of pages all the illegalities that supported the nullity of the elections. The second case is the legislative elections in 2015. In the parliamentary elections of December 2015, despite the lack of competitiveness and electoral guarantees, the opposition coalition party, the MOOD, won the supermajority seats in the Congress. A few days after the elections, several candidates from the government presented different claims against the elections. This time, the electoral court acted in a very different way. That court not only admitted those claims, but also issued preventive measures that suspended the election of 4 congressmen, including 3 of the opposition. The clear purpose of that decision was to invalidate the supermajority of the opposition coalition. Amazingly, after almost 3 years after this rule, the electoral court has not yet decided the case, so its preventive measures are still in force. Third case is the rejection of presidential recall in 2016. In this year, the exercise of the political rights of Venezuelans was further restricted again when the electoral administrator, with the support of criminal courts in that case, suspended the presidential recall procedure. This recall procedure began with a formal petition before the CNE, the administrator, in March 2016, but this request was illegally delayed by the electoral administrator, establishing formal conditions that deferred the procedure for months. Finally, in October 2016, several criminal courts decided to suspend the recall procedure, considering that the opposition coalition committed fraud in several states. Due to that, the electoral court ruled the suspension of the recall procedure nationwide. This suspension, more than 2 years later, is still in force. Fourth case is the National Constituent Assembly elections 2017. Professor Alarcón explained the facts very well. In this year, the National Constituent Assembly was installed in Venezuela, violating the constitutional rules without electoral conditions and with non-transparent results. Because of the lack of electoral guarantees, the Attorney General of the Republic demanded the suspension and nullity of that electoral procedure while it was still in progress. However, the Electoral Court declared inadmissible the claim based on legal technicalities and formal errors in the way that petitions were written. As a consequence of that refusal of the electoral justice, the National Constituent Assembly overruled the Constitution and assumed absolute powers, degenerating into a tyranny, as was well explained before. And finally, the presidential elections, the presidential election 2018. On May 2018, the National Constituent Assembly called for presidential elections 8 months before the end of the presidential term. Although the country is immersed in a deep humanitarian crisis, in a very high economic crisis, and with levels of popularity lost less than 11%, Nicolás Maduro was reelected. Of course, it was a rigged election that violates all the electoral integrity conditions. For this reason, a relevant part of the international community, as is known, expressed its rejection of that elections. Due to those evident electoral frauds, several claims were filed before the Electoral Court. Once again, in only a few days, this court rejected all of them, arguing again legal technicalities and the absence of total evidence, denying even the admission of the claims. Main consequence of Venezuelan electoral judicial authoritarianism. The first one is the loss of electoral competitiveness. Electoral judicial authoritarianism contribute to the loss of electoral integrity. In an active way, when electoral judges annul authentic elections and prosecute opposition parties and candidates, in a passive way, when allows serious electoral frauds and electoral violence in favor of an anti-democratic government. Okay, yes, I am just concluding. The second consequence is the influence on the electoral and democratic behavior of the voters. According to the statistics of the Center of Political Studies of the UCAB, in 2013, 77% of Venezuelans expressed that it is worth voting, even though the electoral system was not transparent and reliable. In this year, 2013, it was a 69% of voter turnout in the presidential election. In 2018, at the contrary, only 46% considered that it is worth voting, and the voter turnout of participation level go down to 18%, according to the data of the Lima Group and international observers. So, this allows to conclude that electoral judicial authoritarianism support the loss of integrity of the Venezuelan electoral system, its transformation in a non-competitive authoritarianism, and damage the democratic behavior and the electoral intentions of Venezuelan voters. And just to finish, 5 or 6 main and short conclusions. First one is that the electoral judicial authoritarianism happens when an authoritarian government is supported by the electoral justice ruling as its political weapon to keep the government in power. Second one, the electoral judicial authoritarianism is not only consequence of the partiality of some judges in pro of one or another party, which is normal, happen all the time, but the total control of government over the electoral justice and its total lack of independence. Third, to avoid this judicial authoritarianism, it is essential to improve the judicial independence, to keep a strong separation of power system, and to reinforce the state capability, as was very well explained by Professor Ponce, Professor Romero, and Professor Alarcón. Fourth, at the same time, it is necessary, as Carmen said, to reinforce the electoral judges' nomination and selection procedures, and of course, to improve their professionalization, specialization, and judicial ethics. In Venezuela, for example, no one of the electoral justice never has had a specialization in electoral law, even in constitutional law or administrative law. 5, it is important to be aware that constitutional justice plays a key role in electoral integrity, since electoral judicial decisions can be challenged before the Constitutional Court. And finally, I want to leave a question to be thought, that is, if the electoral judicial authoritarianism could be or not a threat in other Latin American elections. we have two cases with some signs. One of them is the Bolivian case, when recently both the Vice President and the President of the Electoral Tribunal resigned, alleging institutional problems, just when it's coming soon the judicial decision about the possibility of Evo Morales to run for president for a one more consecutive time, even though the Bolivians said no by referendum. Also, it is the Nicaragua situation when the President of the Electoral Tribunal has been accused of avoiding the control over several electoral frauds in order to allow President Ortega to be reelected on 2011 and 2016, and in consequence was individually sanctioned by the USA. In both cases, there are several expressions of a weakened judicial independence that could become eventually in an electoral judicial authoritarianism if it's not amended soon. So that's all, and thank you so much.
Thank you, Daniela. Let me, before open the floor to questions and answers, just two very brief comments provoked by the very enlightening lecture from Daniela. The first is that maybe it's the time, reflecting on electoral courts, on electoral justice, to bring back here to these matters the old and never finished discussion about the role of the constitutional courts as the ultimate decision level in a constitutional democracy. I mean, the limits, how to control this last control power, can it be controlled or not, or which context of exigence in a democratic society must exist to the last instance courts. We never discuss that point in electoral justice. And right now we're having final courts, final decision courts, such as in the Venezuela case, that, I mean, maybe it's the time to think how to control the control of the power, no? I mean, to bring back, as I said, a very large and rich discussion about constitutional justice. And the other thing, the other issue I like to point on is that I agree with Daniela. Electoral justice, I mean, electoral authorities, even judicial, even administrative authorities are, I think, in a risky time in the whole democracies, but particularly in Latin America. And I just said this, I made this reflection last week when Mexico assumed the presidency of the UNIORE, of the regional EMBs of the whole country and tribunals. I mean, the risk comes from two different sources. The political, social, and economic external pressure. I mean, the pressure from governments, from political parties, from interest, real power factors, and so on. But also, and that's maybe most dangerous, an inner risk, which is the risk of the concentration. I mean, to be the risk to be soft and get to try to be well with the power. I mean, I don't know if I'm explaining myself. Not just friendly, but you must have as an electoral body, condescending. That's it. You must have a deference with the power, but not condescending. And that's, I think, right now. Yeah, I mean, yeah, that's it. Well, you already get it better than me, better than me English. So, but I think that we must reflect on that, because it's a problem from abroad, from outside, but also a problem from inside. I mean, the identity and the essence of an electoral authority can face also this risk. No? And that's enough for me. And I open the floor. I don't know, Daniela, Carmen, if you want to have a brief comment.
Yes, a brief comment about the Constitutional Court. I actually studied this case of electoral justice because my research here in Boston College as visiting scholar is precisely the role of constitutional courts in democracies that are under authoritarian regimes. No, this is my topic, and I was studied that, and then I added the electoral justice. And I have been concluded, I have not concluded all the research, but so far I have concluded that constitutional court is not working. It's not working. It's a problem of the rule of law and constitutional democracy. It's unbelievable, but it's true. I have been teaching constitutional justice for 15 years. I'm trying to protect the constitutional justice, but right now I think it's not working. If you check the index of the rule of law index, the Freedom House index, and the way of constitutional review or judicial review, I mean, if the countries has constitutional court or a judicial review system as the United States, the 10 highest ranks are all judicial review. The lowest, all the countries that doesn't have rule of law and doesn't have democracy have a constitutional court, has a constitutional court. And when you look deeply, you find not only in Latin America, in the case of Venezuela, the case of Bolivia, but also in the rest of the world, is Turkey, is Poland, is Congo, is Moldavia, is Thailandia. In all that cases, the Constitutional Court is the main arm of the government, of the authoritarian government. And it's because of what you saying before. It's because Constitutional Court is the highest control. Nobody controls the Constitutional Court. In the electoral justice, it's a higher, the Constitutional Court is a worse problem than the Electoral Court. Because if you have a good Constitutional Court, you can control the electoral judges. So at the end of the day, the problem is Constitutional Court. We have to think about that. I don't know, I have not finished that. I don't know if the solution is to rest in peace all the constitutional courts, or maybe to redesign, probably will be the redesign, but we need some kind of control, absolutely.
Well, while we expect anxiously the end of your research, I open the floor for some questions. Yeah.
We have lots of mics here, you can choose.
Well, I feel that I'm the only one that is not an expert on electoral issues, but I am very grateful for this panel and the other one because I learned a lot these days. But so what I realize is that all that you are putting all this effort in is on making candidates that the people want to be there, to make the path possible to be there in power. So the thing that concerns me as a normal citizen and not an expert is what happens when the candidate is already in power, but if it is part of electoral integrity, the fact that they make promises in campaign that then they don't respect. I am asking this because this happened in Argentina this year. So what's the point of making one reach the power without fraud, without violence, without corruption? But then that person doesn't do what he promised in campaign. So the question is, if you think that this is part of electoral integrity, if do you know if there are some remedies to this in Latin American or in the world? And if you think that, I was inspired to ask this question because you talk about broadening electoral access to justice and what we can do as citizens, because just punishment with vote isn't a remedy, because it could happen again. I mean, you can lie to me again, and I will vote you, and then you do whatever. And also because maybe it's too late to reverse what is done. So the question is, it is part of electoral integrity with remedies. Will the electoral authorities have to deal with this or not? What we can do, we have to create legal duties of complying what you promised. That is the question.
You don't mind if we set together a couple of questions more? Emilio? Yeah. If there are.
Actually, excellent presentation, both of them, but I was really fascinated by the research that Daniela is doing on judicial authoritarianism, and it's a little bit depressing when we think of Venezuela. But I want to just go on the side of hope, and if you were, because you already point out where are what we should not do, right? And you're talking about those indexes that relate the existence of a constitutional court to levels of democracy, very low levels of democracy and authoritarian regimes. But if you were given the opportunity to think of a reform of the judicial system in Venezuela, how would that look like? And is there anything in the region that is good practice in terms of organizing a judicial system that works for democracy? I don't know. I mean, you are the experts, so I would love to hear some thoughts on that. Señor Cónsul.
Okay. When I was doing my sabbatical in Oxford University, a very well-known political scientist, Lawrence Whitehead, who was dedicated to the subject of Mexico. He taught Mexico in Oxford and written many articles and books about Mexico and Mexico's political system and Mexico's transition to democracy, etc. He held the view that in Mexico it was impossible to move from authoritarian rule to democratic governance because there wasn't any credible, any trustworthy institution among society that would allow this. If no one would believe political parties or whomever to do the transition, and they would think it was once more a fraud. Later, with the INE, before IFE, Electoral Federal Institute, and the tribunal, he changed his view because these two pillars of Mexico's electoral wisdom were the trustworthy elements that allowed for the democratization of the country, from a highly authoritarian regime to a full democracy. And this is to the extent that, as far as I remember, but please correct me, Dr. Alanis, there hasn't been one resolution of the tribunal that has not been contested to the point of not fulfillment. Of course, the loser is always angry, sad, but other than that, he complies with the resolution of the tribunal. Since the tribunal got full jurisdiction, there hasn't been a single resolution that has been not put into effect because the subject of that doesn't allow it. Whether it is, and it could be decisions about who won the presidential election or who won any governorship or municipality. So that shows that, notwithstanding that it is an element of the Mexican democracy, that it has a great deal of pressure and tension from political parties and everyone, so far the resolutions have been accepted. And the difference was that before the existence of the tribunal and the INE or IFE, the way the losers sought to arrange the problem was take the streets and take demonstrations and with lots of political violence. So that makes a difference. The tribunal and the INE have made a difference of before and after.
Is there one last question? Because we're on the time.
It's just very a quick question. It's very related to the first question. So I recall that during campaign, Mr. López Obrador was talking about the midterm kind of consultation to ask the people if they were happy or not after the first 3 years of his mandate. And if the result is no, I wonder what's going to happen. Is going to be an interim president? Is INE going to call for a new elections? Is INE going to be involved in this consultation, or is it going to be a consultation as the new international airport, or how is it going to be arranged this? Because I'm very confused about that. What would happen if the people say no, we are not happy, like you are not fulfilling the promise during campaign, so we want someone else? What would happen? I don't know.
Thanks God I'm the moderator here, so Mari Carmen should answer that question. We are on this time. Last one?
Yes.
Yeah, sure.
No, it's just a brief comment in regards to, in regards to the role of the constitutional courts and all that. I think I would be cautious in terms of blaming the constitutional courts on the problems of the the functioning of the judiciary, because we have good examples of constitutional courts that work. In the case of Venezuela, we don't even have a constitutional court. We have a constitutional chamber. I mean, you know that better than me. But I mean, it's something similar to our yesterday's discussion in regards to the electoral bodies. I mean, what makes an electoral body consistent and reliable and efficient and fair? I mean, there are many institutional variables, but there's also the institutional setting of the country, the fact that there was a deliberate attempt from Chavismo to control the courts, to pack the courts, because there was, at the beginning, there were attempts of, say, the constitutional chamber and the constitutional and the electoral chamber to preserve their autonomy, but all of that sunk as the regime became more and more dictatorial. I mean, I remember very clear the confrontation between the constitutional chamber and the electoral chamber in regards to the first recall referendum and the attempts to preserve their autonomy. So there has been a struggle. Has progressively deteriorated, but to blame it on the institutional design, I think, I mean, this is goes much beyond the institutional design, as we kind of discussed yesterday in regards to the institutional design of electoral management bodies.
Well, I think Daniela and Lorenzo will answer more than me. But talking about the judicial models, I'm pro-constitutional courts. I think that we are facing, as Daniela named it, the authoritarian judicial model or constitutional model. But it's because we are very far from ethics. And we have to still work on independence of judges, models of appointing and selecting judges. And Lorenzo was telling me, which is very important, it's accountability and public auditing. So the involvement of civil society following and demanding the courts a clean work. It's necessary. I think that's on one side. On the other side, we completely corrupted the model, and I think this is worldwide, the model of checks and balances. We are facing a model of threatenings or threats among powers. In our countries, the Constitutional Assembly or the Parliament or the Legislative Assembly, if they don't like a ruling from the Constitutional Court or the Judicial Court, they pass a reform and change the judges. And if the judiciary doesn't like a new law, a just passed law or a constitutional reform, they declare it unconstitutional. So the activism of powers, and of course the intervention of the executive, the president's, the executive powers is amazing. And if you add corruption, so we are in the worst world that we ever imagined. So the solution, I'm not discovering hot water, but the solution is the independence of judges. So you need to review, we need to review the models of selecting judges. There are international standards to do so. I remember the Venice Commission standards, the Inter-American Commission of Human Rights standards, and the United Nations standards about the independence of judges and how to appoint them. And if we follow the rules, I mean, it's what we have to do. It's so easy to say it, but I think we don't need to develop new models of constitutional or review or control. We know that it works if it is under ethical and legal standards. And about and the other question about what would happen and which mechanisms exist to control or to ask elected authorities to comply their promises, where there are different formal mechanisms that citizens can use, but they have to be in law. So that's participatory exercises such as referendum or impeachment. If we go to another extreme, impeachment by Congress, or also there could be a judicial intervention if they do something against law. But the problem is that the highest authorities are controlling everything. So if we don't start controlling the controllers, as Dr. Córdoba said, it's not possible to do so. So the mechanism that Hector just mentioned is like a referendum, or in Spanish it's revocación de mandato. How do you say in English? Recall, sorry. A recall referendum. That's a good point of a good starting point, but you have to legislate it. So in Mexican case, our next president, he takes office the 1st of December. He offered that. In 3 years, I'm going to do that, but it is not in our constitution. So first he has to pass the reform. And then let's see. Lorenzo will be the president of the Electoral Authority still. So if it happens, we need the reform, and then he wants to do that. And that the consultation and the consultation is about that issue. So there are formal mechanisms, but if the authorities don't permit to apply freely those exercises.
Yes. Just finishing, 30 seconds. Absolutely agree with Carmen. The answer and the key is separation of power, and rule of law, of course. For that, we need stronger institutions. No? How? I don't know, but this is the key. And very interesting, the point of Professor Comblit. It's true, it's absolutely true. An authoritarian regime can misuse any institution in its favor, anyone. The central bank, the criminal court, the Constituent Assembly, for example, any institution. The problem is that the Constitutional Court is the most powerful of all institutions. It's the only one that nobody controls. This is the problem. So it's almost out of the separation of power of check and balance. No, the only control is a prior control when nominate the judges and a little after that. But this is the main problem. So all the institutions can be constitutional harbors, no? But Constitutional Court is the most dangerous, absolutely, no, I think.
Well, thank you very much. I think this was a wonderful panel. I will play the role of the immoderate moderator just to close. I will add just another issue. Because of your answer, and you are not an electoral expert, no? And that's maybe because, I mean, I feel compelled to say this. Maybe it's also, and we forget very oftenly, a matter of educating the citizenships. I mean, the civic culture is something, it's not a matter of just electoral justice, but it's something that stands beside the functioning of all democracy. Tocqueville says it 150 years ago about the United States, by the way. Because when the people is angry and they are not compromised with democracy, its principles and values, it's very easy to see how democracy gets into exercises we are seeing around the world, such as the recent one, such as Brazil, for instance. So I think we must rethink beyond, you know, the institutions that must be strong, robust, electoral designs, constitutional architecture, that means. There is also the civic education issue. And I think we forget it in the last 20, 30 years. And that's the results. Thank you so much.
Thank you. Well, we are out of time, so we don't have time. We don't have time, and we don't have force for more. No, no more, and no long closing remarks. Just 1 minute. First, thank you to the Clough Center for hosting here these 2 days. The Clough Center has been very generosity all this time, and he opens its door to the Latin American constitutionalists and the electoral integrity in Latin America. So it was wonderful, this opportunity to have all of you here because of the Clough Center. Second, thank you all the speakers. Any one of you were better than the other, and I think we have great conclusions, great ideas. I promise I will write a draft of a final report. Any one of you will check, and then we can publish it with the main conclusions of the conference and recommendations, suggestions, so we can have it in a written way. Third, of course, I have to say thank you especially, first, Professor Carmen Alán. She's the co-sponsor with the UNAM Boston. And, you know, she speak twice, she checked the program with me. Maybe she can sing a song, no, before we can go. It's the only thing.
I don't recommend that.
And also, of course, Professor Benigno Alarcón, who also checked everything and has the idea of the final report, and so he's going to help me with that. I think
He's in charge of that.
Exactly.
That was not the idea.
Okay. And finally, thank you to all the attendees. The question, I think, were all the questions and the discussion was very, very good, and I learned a lot. So thank you so much. Finally, we have a special guest today in this final part of the conference. One is Patricia Tyler. She's the director of continuing education, correct me if not, of the Boston College, and Professor Susan Simone, who is the director of international affairs of the Boston College Law School. Both of them were very, very glad to have you here, and they asked me to present you briefly main ideas of Boston College and how can we have exchange with your university in each case, and your ONGs and your institutions. So thank you, and you have the microphone.
So I would also echo what Daniela Profesora Urosa had to say. For Dr. Alanis, thank you very much. A la parte de UNAM Boston, Su Señoría, Su Excelencia, the Consul General of Mexico here with us today. We're very fortunate to have your presence and all of the illustrious professors that are joining us here today. And of course, without the energy and vision of Profesora Urosa, which we are very fortunate to have here at Boston College Law School, and her wonderful husband, Jose Ignacio. It's really a community here in Boston and a community throughout our great city. I wanted to let you all know that we are continuing with engagement with the Latin American community throughout the course of this year, and coming in less than 2 weeks, on the 13th of November, we will have the visit of the judges of the appellate and state level of Sao Paulo and Espírito Santo on the subject of acceso a justicia. And so in particular, the comments made by Dr. Alanis on the issue of judicial independence is going to be a very critical conversation that we'll be having. We would love to invite all of you to come back to that Clough Center sponsored event to exchange some ideas and perhaps discuss some issues of electoral integrity. I was fortunate yesterday to hear about how the process in Brazil from Pipa Noares was very holistic and well managed, and yet the result remains the question that was raised by a number of our scholars today, how to deal with that result. I wonder if we can get a few comments from those judges. And then finally, we'd like to invite your students and your colleagues to continue to participate with us throughout the year. And my colleague Patricia Tyler will indicate a few other programmings that we will have, which will again focus on Brazil in January, and for Peru and that region in August and during the summer.
Oh, sure.
Good afternoon. I will be very brief, I promise. I know it's the end of a long day for you. My name is Tricia Tyler. I'm the Director of Continuing Education for BC in the Office of the Provost. And I work very closely with the law school to develop continuing ed and professional development programs for BC Law School alumni, for local law professionals, and for lawyers across the US and around the world. Many of our programs are in person, though we will soon have some online offerings as well. I have 2 programs, very exciting programs coming up in January that I want to tell you about. They are both part of our Insights programs. One is called Insights U.S. Legal System, and the other is Insights U.S. Constitutional Law. They are both 5-day programs, Monday through Friday, and they will be offered the first full week of January in 2019, January 7 through 11. They are a collaboration between continuing education and the BC Law School, and the BC Law School faculty will be instructors for these programs. The audience is international students, legal educators, and legal professionals as well as U.S. students who are considering law school. For the U.S. legal system program, this will be the second time we've offered it. We had a very successful program last month, very successful offering of this program last month. It will be the first offering of U.S. constitutional law in January. The curriculum is very interesting. The first 2 days will be shared by the two programs. Day 1 will be an introduction and history of the U.S. legal system, and Day 2 will be professional responsibility and role of the lawyer in the U.S. So both programs will attend those first 2 days, and then the groups will split. The U.S. legal system program will have 3 days where they examine how to handle different types of cases. 1 day on civil cases, 1 day on business transactions, and then the final day on criminal cases where students will have the opportunity to participate in a mock trial, which I know was a big highlight for the students in the October program. The U.S. constitutional law program will be a little different. The last 3 days will focus on key amendments to the U.S. Constitution. 1 day will be on the First Amendment, which is freedom of religion, speech, and the press. 1 day will be on the 14th Amendment, which is on civil rights, both very hot topics right now. And 1 day on the future of constitutional law. The last day will also include a very special session by visiting Professor Pedro Lanza, who will compare the rule of law in the U.S. and Brazil. The cost for the 5-day programs is $1,000. It includes all program sessions, all materials, and breakfast, lunch, and snacks each day. And the registration deadline is the end of November, November 30th. We do have an opportunity for a limited number of $200 scholarships for the U.S. legal system program, and the information about that is on the handout that you should have received. We've extended the deadline for that scholarship application to next Thursday, so it is coming up very quickly. If you have any questions, please feel free to come and see me afterwards, and I hope that some of your students and colleagues will be able to participate in these programs with us. We'd love to welcome them. Thank you.
Thank you.